Okay. All right, we're all set there. Um, we want to go ahead and start the meeting, Judge.
I can. Good afternoon, Peter. Just for clarification, is this the DSA issues meeting or is this a meeting of the issues committee regarding DSA issues?
I think this is a joint subcommittee of that's from the DSA and Issues
And
Committee. Yep.
okay. All right. Well, thank you. I'll begin with our conflict statement. It is the duty of committee members to avoid conflict of interest and appearances of conflicts of interest in performing their duties as members of the Distinguished Service Committee, the Issues Committee, and the North Carolina State Bar. Any member of the committee who is aware of any personal conflicts or appearances thereof with respect to the matters before this committee should disclose those and recuse themselves accordingly. One other caveat I'd like to add, we may be discussing something that happened at the last general meeting, and I'd like to refrain from mentioning the DSA nominee or the person that voted in the negative, so we don't somehow reveal the identity uh,
Sure.
of the parties. Okay, I think that might come up, but this is we're looking at, I guess, two issues, and they kind of intersect. Uh, we're looking at a policy for nominees who we discover through our due diligence check to have some past public discipline, criminal history, or anything else that might be embarrassing. And then that sort of segues into another idea that Judge Hennon and I spoke about at the on Friday of our last bar council meeting, perhaps including as part of that policy a courtesy in which we uh, speak to the counselor in the district where a nominee is from to see how that's going to go over in their district. And it would not be a veto for that counselor, but it might just give them a heads up and see how the nomination process could be managed. So, with that, who is presenting on behalf of the bar?
I'm happy to get us started. I have worked on some general proposal to get us going to think about how this might work. So generally, just before I share it, I think my recommendation for the operating policy of this committee is something I've said a lot lately, which is first, do no harm here. This is an optional thing for us. We're not required to give someone an award. There's not a right to an award. So we need to make sure that if there's significant doubt or concern, then we should always err on the side of not giving an award just because there's not any duty to give it. So, I'm not saying if there's that it should be hard line, you have to have completely clean everything. But if something raises a doubt, I think that's fair enough for this committee to say, let's move on and find another good candidate. But we talked, there's been a lot of discussion in emails and conversations about this for many years, actually. And I think some of the concerns are about what level of discipline, what levels of discipline should have weight in a decision. If someone has past discipline, how would the committee deal? How should the committee weigh um, dismissals with letters of warning or letters of caution, or really old, admonitions or things like that, and so what I tried to kind of work on here is something that considers all these things and puts in some criteria and a process potentially for the committee and the council to deal with these things. So I'm going to share this, and this is in a rough form, and I'm absolutely think this committee should take a look at it and suggest changes or scrap it if it's not something that that you think is a good idea. But I wanted to make sure that we got something on the table to at least start us off to look at. And so I'll share this with you guys now. So generally, this is just a timeline, and you're seeing my Word document here?
Can you enlarge it just a tad,
Yeah, absolutely. Yeah.
please? I need new glasses and I'm having trouble, and I missed my appointment this morning. So thank you.
So,
Thank you.
so what so these are just my thoughts here. That the committee or the staff person to the committee can check a nominee's public discipline when a nomination is received. Um, that is public discipline. It's on the website. It is not confidential information. They can report that to the committee. And this is just hypothetical ideas. The committee could consider a policy that public discipline, which would be, reprimand, censure, suspension, state suspension, or disbarment within the past 10 years is just an easy, like a hard line. We're not going to give an award to someone who got a public discipline within the last 10 years. If there was discipline that maybe is older than 10 years, the committee could consider that when debating the merits of the nomination. And if it chooses to proceed, I think in the closed session should disclose that information to the executive committee. So they're aware of it when they're, it's hard for the committee to know. I think that should be something that's disclosed. Again, this is all public information. If through this process the nomination gets the executive council approval, you get the waiver signed, and then you check the private discipline for admonitions. My recommendation is you really only do 10-year look back. But again, for debate, my opinion would be that dismissals and letters of caution and letters of warning don't really shouldn't be something that the committee is terribly concerned about. Any lawyer who's practiced for a long time in certain fields is going to have a lot of dismissals.
Well,
Yeah,
a dismissal, I mean, you could disqualify somebody by just filing a frivolous complaint against them.
that's right. That's right. Yeah. So I wouldn't put, I wouldn't worry. I think, we consider discipline being an admonition and higher. You could consider maybe dropping that down to looking at a letter of warning, but just for this example, I have it as admonitions. If there is a recent admonition after this point, because this is after the waiver is signed, then my recommendation would be that the chair of the Distinguished Service Committee and the council to that committee consults with me and the state bar president using a criteria that I'll share a sample of or an idea of. If they don't think that's a significant concern, then it can proceed. If that group has a significant concern, then they would refer that back to the Distinguished Service Committee for its consideration. And they can decide how to do that, but you would go through the council and you would still need to disclose that in the closed session meetings. Same with criminal history. I think because this would be something we don't see until after the waiver is signed. You have a consult. If there's concern, send it back to the committee for its consideration. And if there's a pending grievance, then I would recommend that you just defer the process until that grievance is resolved and then deal with the outcome. Unless you can get assurance from the Office of Counsel that the grievance is going to be dismissed, just like we kind of do in the administrative committee. If we don't have confidence that it's going to be dismissed, then I would just hold that until it's resolved. Just to get us going, I put together some potential criteria. It's what, a lot was mentioned in those email threads. What level of discipline are we talking about when we're talking about public discipline? How severe was the misconduct? What sort of harm was caused? How recent was this public discipline? And, what is potentially the public or profession's reaction if this person were to be given the award and then they find out that this person has public discipline. Similar for criminal history, severity, time, conduct post that activity, and relevance to the lawyer's role. If it's tied into their professional duties, I think that's probably more concerning than a traffic ticket or those types of things. Admonitions, same thing. Multiple admonitions for the same type of behavior could raise significant concerns. Recency, severity, those types of things that could be considered by both the committee and by this consulting, by the smaller group if it's post waiver type situation. So this is just get on paper. I'm happy to scrap this whole thing if you want, but I wanted us to have something to go by and start working on if this is the kind of path this committee was interested in looking at.
I have a couple of questions.
Sure.
Well, 3 questions. Number 1, are we to decide today, or is this something that we can take under consideration and maybe?
Oh, yeah. This is not.
Okay.
Yeah, we do not have to decide
Okay.
today. This can be something that I have on our issues committee agenda that we would report the progress of this to the issues committee. If there was a decision today, we could report and make a proposal that the issues committee and the distinguished service committee could consider next week. But this could take multiple meetings. And if there are things you want us as staff to flesh out or provide information for, we can do that and meet again as many times as we need to get this right. It's not required that it gets done today.
Okay. So then one question that I have, if you scroll down just a little bit, please. Right there. Oh, back just there. So I think where I'm not sure about the process is that if the nomination gets executive or full council approval, then check for these other things. And if the group decides it's not a significant concern, proceed with the award process. I'm thinking maybe you could look for these things before it gets to the full council. And maybe at the time that it goes before the council, alert them to the fact that we know about it and it met the criteria that you listed on the next page, and that we felt that perhaps it was worthy of proceeding or met the criteria. And then where you have here, if the group decides it's not a significant concern, I would just be more specific in saying what that group is. Is that the council?
Yeah. In this case, this would be the small group.
That word
Okay.
just threw me
Yeah,
off. I said,
sure.
what group? Who's the group? It's in dot A and B, bullet A
Mhm.
and B group. It just kind of threw me off.
Judge
The,
Hennon,
the issue is when we get the consent from the lawyer.
okay.
Well, okay, so maybe I don't know that part of the process. Well, at that point in time, the lawyer is informed of being considered for or having been voted to get the award. And then we have to go through that process of saying, oops, well, we don't mean to give you this award because we found out something about you. That's why I'm getting at, can't this be done before it reaches the point where it's voted on and the lawyer is notified?
Yeah, but I think for the private
That's not where
discipline,
we are right now, but
right, with a private discipline, we have to get a waiver for it. And
I
so,
see. Okay.
It is kind of
Yeah.
uncomfortable.
Yes,
Right.
yes. And maybe that part, the admonition, where you get a waiver, then check for. Uh, mm. I see.
It's tricky because I think we've done from early on a better job of making it clear that they are being considered for this award and not, you're going to get this award assuming you get a clean background check, which I think is what we did at the beginning, is how it was communicated. I think now it's a little more careful that there's not a guarantee that you're going to get this award, but that is the difficult part. And it certainly, raises a question that, I have an opinion on, but um, whether we need to worry about private discipline at all if it's private. Um, and, you wouldn't need a waiver in that sense, except for you would need it for the criminal background check. Uh,
If it's private, does the committee still get to review it?
so in this scenario I put in, if it was private, it would be considered first by the chair and the president and the ED and staff council. And if it was not of a significant concern, it wouldn't go back to the committee. But if it was a concern, then it would go back to the committee for its consideration.
How would we even get to see that though, if we didn't have consent?
No, you'd have to, and you'd have to get consent. I think that's the hardest part as it relates for private stuff. We have to get a waiver. It's the only appropriate thing to do to be able to share that with members of the council. I could pull up someone's information right now on our database and know, but it's not appropriate to do that. And share that information with anyone without that waiver.
But the ED and the president and the committee chairman or the bar staff could.
Well, this would still be after you get the waiver.
No,
Still
Yeah.
have.
Yeah.
I can't look at anything that's in grievance.
No, she's in, ethics can't look at grievance and grievance can't look at ethics. I have access to both databases, but I don't do this unless there's a reason. I mean, you don't just go around searching people's disciplinary history.
Well, I think it's important to have that information about the background. It will certainly be a bit embarrassing if you make an award to someone that has a history that would cause us to be red in the face.
Mm-hmm.
And sometimes too, being able to ask someone that in the district that knows a little something about the candidate could help. Sometimes people look really good on paper and you don't know that their personal lives are a big hot mess that could prove to be a source of embarrassment, and that very discreet inquiry could reveal that.
That's not a bad idea, but I also think, I mean, if somebody's been nominated, hopefully these people would know about whatever issue it may be, but I think it's probably going to be obvious to whoever the intended recipient might be asking the waiver. They're bound to know that that's going to come up.
Well, it might depend on what's in the package. If you have a package that is replete with glowing letters of recommendation, then yes, that may be true. But when it is short of that, you may not uncover something that you might want to know.
I think it's a great idea to reach out to somebody in the district as part of the vetting process. I think that's a really good idea.
Or at least make sure that you have a packet that is, we don't have to say you must have 10 letters. I don't mean that, but just that you have that you have a good sampling of the reputation of the lawyer represented by the letters or recommendations that you receive.
But, sometimes we get a lot of packages that are not from counselors in that district. So as a courtesy to them, so they're not blindsided when they get back to their district and someone says, "What in the world are you doing in Raleigh? I heard you gave the DSA to, George Lauren." um, I think that counselor needs to have a heads up.
And I,
Well,
I would
I can
recommend,
remember.
go ahead.
Oh, sorry,
Go
Peter.
ahead,
I
Deb.
can remember being asked to, or seeing a nominator being asked to provide more information and get some more letters. And sometimes the nomination would go through, sometimes it would not, and sometimes it would be withdrawn. It just varies, and that's
Well,
why I think it's
maybe
important.
if I could speak up, because I know when we've had nominees, a lot of times we do ask for more information. We've had a few nominees a few times and we get
Mhm.
2 letters in. And I mean, I'm not saying any of the people are not, fine attorneys and so forth, but I think we've been trying to ask for a little bit more because there's a lot of really good attorneys. We've been asking for a little bit more to be the Distinguished Service Award. Um,
I think that that is a different issue, and Mary and Judge Hennett, that is something that we are going to look at, and Judge Cobb
Okay.
has sort of started
Okay.
some groundwork on that. I think that we
Great.
do need to have some more requirements for all of the nominations that we get, because it seems like we're getting a lot of nominations from big firms where one person just writes a letter and then everybody else in the firm signs it, and it's from somebody in their firm. And there's just a lot of things, but I think that's a different issue. I think
Okay.
this is specifically about
The
somebody that's been nominated and has been approved by the committee, the DSA committee. Everybody thinks they look great, and then we do the background checks, and something pops up. And I
So
think that this is specifically for that, but I do think everything you're saying is right. We do need to work
okay. Thank you.
on the
I,
packets.
I see the distinction.
what I would recommend as it relates to the nominees counselor is if they were not part of the nomination process, I would recommend that when you get the nomination, you invite them to either appear or provide, a statement about the nominee confidentially to maybe appear to the DSA committee. I would recommend that you kind of do that before you even approve the person for the award. Like invite, if this someone has been nominated, you invite them to address the committee about the person or something like that. So you don't get so far along before you find out that this person is does not have a reputation that would be proper for the
Right.
committee.
And it's
Um,
not just that, but you go into a counselor and saying, "Hey, they want to nominate this guy. What do you think?" And the counselor smiles and said, "Well, that's interesting. He's planning to run
yeah,
for judge in 6 months, or he's,
right.
I
Yeah, I
want to use
think you
this."
would want to maybe do that
Yeah,
on the front end before there's a uh, approval by the committee. Um, and I did originally, when I drafted this, had the counselor from the lawyers district as part of this little consulting group. But my only fear there is that one person who knows somebody is not always, it could go either way. They could really like the person or they could not like the person. And that one person's opinion doesn't necessarily represent the whole district's opinion either.
sure.
And so I thought, well, let's keep the local and that it's also possible that the counselor from that district might have an interest in getting that nomination through and so have a bias there towards it properly evaluating any kind of information that comes up. So I
But
took them out of that part.
right, but they are the elected representative
They
of
are,
the district,
correct. And then
and
if you're doing like a judge in a federal situation, or I always think about it as someone who's trying to get nominated to a military academy, you always have to you get your sign off from your council, from your representative that, they're a good candidate.
yeah,
Um, so it's certainly useful. Um,
and but it would be it would give me pause if you went to a counselor and said, "Yeah, we're going to nominate this guy. We've got about 30 letters," and he says, "Well, I can get you 30 letters that say this is a bad idea."
right.
Well,
Yeah.
I'd want to know that.
That's why I would have them there at the front end there instead of being part of the group that considers any information that might come up later. Um, just,
I think
you know,
that's a good idea. The one issue with that. I mean, I'm from a small district, so I know most of the attorneys, but if you get Mecklenburg or Wake, hey, you've got a bunch of counselors and they may not all know everybody. So that would be one issue. And I mean, I think it's a good idea. I'm just not sure how you pick which one you deal with from Wake and Mecklenburg.
Yeah, I mean, you might have to invite them all, and or they can consult and say, well, I know this person, I'll go talk. Or I think we leave
Yeah.
those details can be up to the committee or like DSA committee, I think, but maybe as a general idea, it could be a policy to consult with the counselors of the district when a nomination is received. But
Hey, Peter,
yes.
is George Lauren in the waiting room? Do you see him?
Yes, he is again. Yep, sorry. He must have gotten kicked out. Okay.
Thank you.
So I want to thank you for the examples of past discipline for DSA nominees, that little chart that you have with the lawyers A through F. That was helpful to see. And I think something like that can help to guide our discussion. Because we may not necessarily know a person's disciplinary background. So most people don't put that in the front page of the newspaper unless it is a public discipline.
Well, these people have all been approved, just so you know.
Well, I noticed that.
Now, let me ask this, and we could come back to it. I just want to redirect it a little bit. What about things that are eligible to be expunged? Is it not too much to ask that if something shouldn't be there anymore and is eligible to be scrapped and erased, that we encourage that be done? And I know it has to come from the nominee, but you call up the one who makes the nomination and say, I got good news and bad news. Bad news is we can't approve it because he's got this past discipline. The good news is that it's eligible to be expunged. And if you're nominating the guy for a DSA, I'm sure for a small fee you can file the paperwork and clean this up for him. Because it does look bad. We're disciplining them on one side and it's public, and then on the other hand, we're giving them an award, and people might pick up on that.
So that's a relatively new procedure, isn't it, Peter? How long has that been?
Oh, it's brand new. We're still trying to feel this whole thing out in the process. And I guess one of the issues just to raise as part of this part of the discussion is, we can expunge this a discipline from our records, and we will through this process, but it's not, we can't control the internet. And so, that could still come up on a search for somebody as part of a thing that, we struggle with it. Anytime we talk about expungement is, we can't cleanse the world of knowledge of it. We can take it off our records and it won't show up in a disciplinary search for the lawyer. But if it was public discipline, it's possible that it would show up in a Google search or an article or on, Old Lawyers Weekly article. So it's not that it will go away. It won't always go away completely. And that, that is just something to consider. I would recommend that we wait out the expungement part until this plays out a little bit more, because we haven't really even, I think we maybe going through one right now. I would think we might want to see how frequent and common this process becomes. But you're right. I think that's the same idea, Judge, as looking at how recent something is. If you have a cutoff of recent stuff, they can't be expunged. And, more recent things, you have to wait a certain amount of time. And so if you are already kind of discounting things that happened a long time ago, you're almost already doing what you're saying, as if it's eligible to be expunged, we wouldn't consider it.
And what is eligible for expunction?
I mean, you have to be it, only, um, I
I
believe
put
it,
it, I
yeah,
put it in those materials just if you wanted to look at it. I think it's the
yeah,
last thing in the materials, but Peter
yeah.
can,
Suspension,
Admonitions, you
right?
know, there's certain types of, it's in here in the documents, but it's certain, there's certain rule violations even that no matter what can't be expunged. There's a 5-year waiting period for admonitions and a 10-year waiting period for reprimands and censures. Any sort of suspension or disbarment cannot be expunged. You can't have any discipline issues since that one discipline was issued. Um, you can only expunge one disciplinary record. You're not eligible again if you've already had one expunged. Um, and any discipline related to 1.19, 3.3, 8.4B, 8.4C is not eligible for expungement unless it was 8.4C was an advertising issue. So there are a lot of criteria, and so I think it would be hard for the committee to go through and determine whether something's eligible to be expunged just by looking at the age of it. Um, but I think that if something is expunged, I think the committee should treat it as it doesn't exist, because that's the point of the expungement process. But I don't know that the committee should consider if something is do its own math or an own analysis to determine if something's eligible to be expunged. I think it'd be easier just to use the fact that it's so long ago to reduce the significance of that discipline.
yeah, I just thought there's probably some factors
There is, I mean, it's
that would
certainly,
be
it's not
useful.
as, yeah, I think that there has to be some, we are trying to make the expungement process as black and white as possible without having it be something where the state bar has to do analysis on it. But um, it's still new and raw and might require some tweaks and changes as this plays out. So I wouldn't jump to making any policies based on where we are at the moment.
So I'd like to say this is sort of right on point of what the committee um, thought we would be doing, and that is to come up with some type of written policy that we could have as a guide. And Peter, I think you've done a great job. This is a great opening salvo. And the reason that in I think the committee's opinion that the subcommittee came up is because we don't even get to finish our normal course of business going over DSA applicants in our regular meetings. And so I urge going forward that we continue having these subcommittee meetings until we flesh everything out. And then we have a policy to go by.
Mhm.
So I really appreciate the efforts you've put in. This is a great leap forward, and I think we can refine this in a lot of a few ways at least, like we've talked about today. And I think we're well on our way. So I appreciate everybody's help on this.
And I will absolutely share this initial document with you, and we can then start, in another meeting, I think we could go through it with you having some time to review it and go through it and kind of look at each section of this process and then refine it and have it something to present to. I think the DSA committee should probably vote on it along with uh, probably the executive committee as well, just so everyone knows what the process is going to be. And we can refine it further. Anything that you have concerns about, I can address and give some options for, like, I mean, I've just kind of vomited this out on paper here recently, so it's not perfect in any way. I don't know if 10 years is the right length of time. Maybe it's maybe it's more, maybe it's less. And I don't know if the criteria is correct. I mean, I think we can probably tweak all of these things to get it how you guys want it. But I think the overarching theme of, we have our main mission at the state bar for the council is that protection of the public, and through that protection of the reputation and integrity of the bar. So we need to always keep that as our kind of guiding star there.
The nomination form itself, you could put some nuanced language in there about what it takes to become a DSA award winner, and maybe cover some territory in sort of a hidden way, and you'd have an out there if the language was exclusionary enough to say, well, you didn't divulge it and it was in the nomination form. Just a thought.
Mm-hmm.
But who is going to divulge it?
I think that's the hardest part is a lot of the nominators probably wouldn't know, won't know much of the private stuff. But they would know the public. But I think if you had a policy that said we can't give an award to someone who received public discipline in the last 10 years, that's something you could put right on the form, because that is something anybody could look up and see.
What about how are we handling criminal history, like a DWI when the guy was in college or something like that? Are we?
Have we only had one of those, Peter? Do you remember?
Yeah, it hasn't. I think that I remember one.
And that was
yeah.
I'll defer to you on that one.
Yeah, I don't and I think it was something like that. It was an old thing that we just said, this was they had their whole career afterwards. So it was kind of hard to say that this had anything to do with their character as being, their service as a lawyer. This was, you have one mistake 30 years ago, that shouldn't be disqualifying, but on its face, it's the same. I mean, it's criteria for that too, where you look at same things, time, how long ago was it? What's their conduct been since? Was it tied to anything they were doing as a lawyer? How severe? You could certainly add in harm, but
is that getting to the committee, or is that just between the ED?
No, see, it would only, the filter for criminal history would be that small group. And if say it was just they got a misdemeanor traffic ticket came up on a background check, for instance, that small group could go, that's nothing, move it on forward. No one else needs to worry about it. But if it was something that was raised a concern, then that would go back to the committee. That group would send it back to the committee for it to consider. And in my current plan, that would then go back through the executive committee and the council.
So right now, I'm the one that I send out the consent forms, and then when I get those back, I get Dottie and some other people here to do the background checks, and then I get that information. And so the criminal hasn't been, I don't think we've hardly had any criminal, but if I got somebody that had a DUI, then I probably would get in contact with Peter and Judge Cobb at that point and say, what do you think we should do when we would talk about it, or whoever else?
Yeah, I think that there would need to be some sort of process for the staff council who's getting this information initially. I think probably you would say if there's anything on these checks, you would want to send it to me. And if it was, I think maybe you send it to whatever this group is. And instead of it being multiple people to decide and have a layer, if anything comes up, this group would have a quick consult on this. You do a Zoom and talk about it. And if there was no concern, move it along. We don't need the whole world to know that this was all there. as you know, we're trying to limit the disclosure of all of this information that is unnecessary to disclose. But if there is a concern, then the chair would have to, and the staff council have to take it back to the committee and disclose it in closed session and talk about it. Something like this. I mean, we can redo the whole idea, but just a nice some sort of process, because I do think it is a gap in our current plan, in our current procedures that that's not, we don't right now have a way that's considering all this stuff that has the disclosure to the people making the votes.
But sometimes it's so obvious that,
Right. I mean, if it's
like a traffic ticket, I mean,
yeah.
they're not going to vote. They don't want to have that and vote on that.
Right. And so that can be cleared up by this small group and just go, this is nothing, we can go forward. So is there any particular parts of this you would like us to look into further and come up with either a better argument for it or some other options?
You want to share it again?
Sure.
Yeah, I think we all need to get a copy of what you've
Yeah.
done so far and maybe regroup after Cherokee and
Okay.
flesh it out a little further after we've had time to do some reasonable thought and study about it.
That sounds
Yeah.
good to me.
I think that's a good idea because I'm sorry I did not get a chance to finish reading the stuff that Suzanne sent. I had to
Yeah.
rework appointments for today to do this, and so I didn't get a chance to. I read like the first 2 pages, and
Yeah,
that's
we
about as
didn't
far as.
expect it. I'm sorry. I didn't, and this one I didn't have ready for anyone to look at until the meeting. So I'll send this out though for everyone to look at, and then we can, based off of if the next meeting is looking at this in some detail, we'll put together an agenda on the key points that we want to make sure everybody agrees on, and flesh out as we need to.
And the more we can do in this committee, the better, in my opinion.
Yeah.
Agreed.
Are we going to use the same committee for, like, we have other issues with the nomination packets, or how's that going to work?
Well, it depends on if you want an outside opinion. If it is a strictly, I think this is a good one for a joint committee because it is something that has affects the entire council and some decision making. If it is a DSA related smaller minor tweaks type thing, you might want to create a subcommittee of just the Distinguished Service Award Committee to meet to recommend those changes if you can't fit it into the meeting time, or request, just let me know and we can try to get you guys an extra 30 minutes or an hour at any particular meeting if there's something you want to focus on.
Yeah, that's not usually very easy to do.
No, it's not. But if we get enough time in advance, we can probably make it work. Yeah.
It's nice to have this additional time.
Yeah. But I would support that the other issues with the nominations stay within the DSA.
Okay.
Any
Yeah.
motions to adjourn?
Well, I just want to say on the record in front of all of y'all that Suzanne really sacrificed. She came back from Costa Rica to attend this meeting today, so we appreciate that.
And
Oh
poor
my,
Judge,
that is a sacrifice.
That
Judge-
is, Suzanne.
poor
Wow.
Judge Cobb had to see all the pictures of my grandson that I'm slightly obsessed with.
They were so cute, so cute.
Oh,
Well,
you
thank
should
you all
be.
for making yourselves available today. I know we got a busy week next week, so I'm grateful that you're willing to throw another hour at us this week too.
This was really helpful. Thank you for setting it up, Peter and Judge Cobb and everybody.
Thanks to everybody.
And Judge Langum for chairing it.
Thank you.
Thank you, Peter. Thank you, Suzanne.
Thank you all.
Hey, Dion.
Travel safe, guys. See you this week.
All right, great.
Okay. Bye.
Thank you. Bye-bye.
Hit it straight, George.
Thank you, Judge Cobb.